Peacekeepers.org is the group. Brian and Mark, shown behind me, are the presenters who put out the challenge that became the hook that reeled me in to listen to the presentation. That hook was, by Mark, no one has been able to rationally explain it, referring to the purpose of the birth certificate. Until now, perhaps. And later, they invite anyone to give them topics so they too can investigate and comment upon the topic offered. Thank you for the invite, guys. Enjoy the video. I went to the site attached to the video because I wanted to comprehend the mindset that they are using to subsequently develop the topic of the video I just watched. The click options available do not offer English common law, but only equity. That then opens up another page which basically pays homage to the idea of equity law, which naturally circumvents the common law by its very acceptance. In fact, the second you use equity, those remedies offered in the common law, those which we have learned throughout the course I offer freely and by donation, is actually where I prove where your true title exists, or legal title exists, and so is automatically overreached through the agreement to use equity law for any redress. Also included within their descriptions annexed to the video was written, "No one is above the law," another catchphrase which needs proper clarification in my opinion. The fact is, every individual is above the law because they have right to dominion initially, in which the law and equity does not effect or has a right to interfere with. And so it's rather more correct to say this, that no one is above their agreements, to which law then regulates rules of action in proportionate share to the agreement expressed or tacitly implied. Okay, let's begin. And yes, this is a basic MacGyvering you see behind me, because I really don't want to take the time in learning how to edit and insert video content within my own video, because to me right now it's more important to get the information out, because I think people are getting a little more antsy as shit is really beginning to hit the fan. Okay, at the 2:12 mark, let's roll.
At least get some people to stop wasting their energy on birth certificates, pots of gold, etc., etc.
Trusts and
Cestui v trusts.
Yeah.
Listening, we heard Mark make reference to the Cestui trust after being prompted when Brian makes reference to a trust. Just as a point of interest, equity law is of notice to the use of land, and so is the foundation to the rules of a trust. Common law is before a trust instrument. Now, everyone listening to this video is subject to a trust. In fact, if a citizen, then a trust, then they are under a trust for sale scheme currently. Now, first of all, the Cestui trust, just so as to provide some clarification, is not a trust per se, but rather refers to the beneficiary whom is the life in which the trust is created for. The Cestui trust means the beneficiary, but also the beneficiary whom before holds rights under the concept of the Cestui use. The use would be the type of title originating from the res, aka the common law legal title held in trust, which becomes evidence of scission of an equitable interest only, whereas the beneficiary would constitute the trust, the Cestui trust, having possession of the use when they received from an original active trustee profit from the use of the profits from the use of the profits garnered from the land held in trust, and so is then called the Cestui trust. In other words, for whom the trust is made for is the Cestui trust. Now, before we continue on with this video, it is important for all of us to use each other's work to share in professional debate, meaning to stay on topic so that we can exchange information so as to properly sort through much distortion concerning law and equity, in order that we can then arrive at the truth of what English law is. It is also important to question me pick my work apart also and dissect the hell out of it, as these guys are doing, so as to remove some of the ambiguity surrounding the sovereign and freedom movement, who, for the most part, do not comprehend what law is, and thus, without possessing this foundation, the principle, namely, and so like in the manner as lawyers who are actually agreeing to circumvent the law through the acceptance into the bar union, will grab only a portion of the puzzle to debate or sell, thinking they have figured it out the entirety of the system, to later then realize that they have still not yet arrived in their full power, thereby still confined under English law. A few seconds later, they present a picture of Parliament. All right, let's roll tape. You know what? We can just go on from here.
A few more of these myths.
Right. Are we going to look at the Houses of Parliament first?
I think start off with the Houses of Parliament.
Right, let's have a look at this one then. So, screen see. Right then, so that's the Houses of Parliament.
Yeah.
Everyone knows what that is.
Yeah.
Hopefully.
So, if we look at the Houses of Parliament, gee wow, that's what controls you people.
Mark humanly states, "This is what controls you people." I expect it's merely tongue-in-cheek, but just wanted to reaffirm what we have so far learned in this English law course. Essentially, that the only thing that truly controls each individual is their agreement to the subject matter controlled by Parliament, government namely, through the grant they have accepted as a juristic federal unit. The government can only administrate over the grant given to them as a legal personage, originally offered through the monarchy, whereby the monarchy holds the settlement of the common law interest, consisting of the entirety of an individual's interest in an estate in land. Now hang on to these words just expressed, especially the use of the word estate. This is the main purpose of this video. We have so far learned concerning what basically English law is. English law primarily is rules of action over the rights to the use of land called estates, subject to everyone being obligated to hold a status, a legal personality namely, under the capacity of a tenant for life, through their own noticed agreements. By the way, another point of interest to which those who research and listen to my series knows, there is no way in which to be noticed in English law unless you are first controlling a legal personality. English law, for greater certainty, does not create rules over people. They create rules over the right to the use of land through a legal personality, to which then people make agreements under English law using a legal personality, thereby forming an obligation dependent upon the type of estate held in law or equity. So the presentation, if Brian and Mark knew this beforehand, while us considering they do offer up some great information, is misleading, especially when they announce later in the video to support their primary thesis is stating nothing happened after 1933 to the name, now used as identification within the territory granted to a government. This is wrong for the reasons hereafter. As I presented in the video before this one, video 42, I explained the core basis of why they are all introducing these 15-minute cities. And before that, the operations of the C19er and the Environmental Fear Campaign, which supports the system. But these operations have nothing to do with real life, as the government only regulates the systemic fiction, which has no right to patent life or control it. If you took the experimental jibby jab, for instance, the poison dart, you just have made another agreement that is based on fiction only. I digress. After I hit upon the true explanation for the reasons for these 15-minute cities, I also then make other references to the epochs within feudal, ancient, and modern law tenure systems that were instrumental in changing, well, essentially moving from a previous title right to an estate land over to an offer of a different type of estate of limitation. This was the change being made concerning the rights of the persons, their right to a new equitable estate and land regulated under a territory. Whereby, in 1925, was the introduction of the Trust for Sale scheme that began a title change into the privileges offered under governments of that era and now continuing throughout this era. Those operating according to this new Trust for Sale scheme, remember, what does equity regulate? The trust. So what does government regulate under? The Trust for Sale. Whereas every citizen is now subject to this new agreement under the guise of the welfare state, which was introduced by the pre-planned run on the banks in 1929, so as to underhandedly herd people to accept the position of a quasi-trustee, an enfranchisement, the assumed owner of a third level of use to land subject to these new title rules, which, like I have mentioned before, is exactly what they are doing today, herding people into another land title agreement, the fourth level of a trust to be more exact, which offers more limitations upon the state interests that they had controlled previously, which before were subject to limitations under the introduction of the Trust for Sale scheme. That happened in 1925 and is currently regulated under the Law of Property Act. Why we use fiat money, nothing backed by gold, because we are simply using the land as quasi-trustees under the construct of a Trust for Sale scheme, who are prohibited from ever acquiring a loyal title because we are all obligated to manage the land through these new territorial estates. So evidencing we do not ever fully own these estates, but merely possess them. Another point, there is no such thing as a loanium title to land, as English law is a hierarchical system of landholding, essentially ending in the hands of the people as individuals whom are not subject to a group because they have inherent dominion over all land. Back to the topic. So the event, the purpose of the original founding document of Notice of Live Birth, is in fact a reference to an estate interest, not the individual as a sentient being created through the laws of nature. Thereby, without this knowledge, Brian and Mark bring the listener along so as to end in another descriptive conclusion, as opposed to a formal explanatory truth. The main reason for this is they are filtering their knowledge through equity, while not yet comprehending what law is. Let's jump ahead so as to bring the video home. Remember to like, subscribe, and share, and scroll to the links below to learn what is law. You do not have to hear my often mumbled oration, coupled with the non-edited mistakes in all of my videos, and so can read what is law for yourself. 225, let's have a listen. So I move up the scale here. Where are we? Well, there we are. Okay, they begin with the Bill of Rights, 1688, Chapter 2, First Year of William and Mary of Orange, Session 2.
The Lord spiritual and temporal, we've defined already in the First Act of William and Mary.
Mm-hmm.
The Commons, we've already defined in the First Act of William and Mary.
Yeah.
Okay? So what we've got here is they are lawfully, fully, and freely representing. Okay?
Mm-hmm.
That means these people are in a contractual relationship. With whom? The people of the realm.
Yeah.
Did you catch the mistake? It states exactly what the two houses of Parliament are in charge of, to which Mark glosses over because the public falsely arrives at the conclusion that government administrates over people first. They do not, as before mentioned. Ministers in government record an estate to record an interest to an estate land, to which through this event, the live birth record, the estate land can pass freely without being encumbered through the inherent inability of the life, the infant mainly, to control their own legal estate interest. Therefore, trustees are assigned through operational law, not by an act of parties, because obviously the infant cannot make an agreement that would uphold the scrutiny of law, and so would suffer the test for lack of mutuality. The trustees now are construed to be as statutory owners, as determined through the warranty, the Settled Land Act 1925, coupled with the Trustee Act of the same year. Okay, let me get back to this and stop the video's already stopped, and show the common mistake made by the people. What does Parliament have control over? Okay, let's just go back here. Start from where we began before.
Temporal, we've defined already in the first act of William and Mary.
Mm-hmm.
The commons, we've already defined in the first act of William and Mary.
Yeah.
Okay? So what we've got here is they are lawfully, fully, and freely representing. Okay?
Mm-hmm.
That means these people are in a contractual relationship. With whom? The people of the realm.
Yeah.
It reads succinctly, representing all the estates of the people. Okay, read that again. Let's look at it. Representing all the estates. There you are. They have a right to administrate over the use of those estates that belong to the people initially. And there are no people, because they are acting as quasi-trustees, citizens namely, who are agreeing to be an enfranchisement of the government by notice of their actions to purchase property under a trust for sale scheme created in 1925 under the Law on Property Acts. And so under, drum roll please, filtered through the law of equity, which is then brought before the courts of chancery, not the English common law. These equitable use titles, now used and purchased under the trust for sale scheme, will come to an end in 2024. I surmise the idea of the 99-year lease that these proprietorship of lords control, we just call them countries. Look to the video, which we just call countries. Now, look to the video previous to this one for deeper perspective. Number 42, titled Inherent Jurisdiction, Rule of Law, and 15-Minute Cities. And the foundational one I did before I began my English law series, titled The Elite Are Coming from My Property. Nope, the law is. The latter one is most likely the best one to begin with. I will provide links under the description to these videos. And so it's exactly what is happening today with the virus pseudoscience theory to move people into another level of land use like they did in 1929 to begin the Great Depression, whereby these new estates will have even more limitations than enjoyed by a citizen today. And I also will interject that when they say on behalf of the people, like I've already mentioned, where are the people? The people only have rights to interact with the monarchy through operational law. And then the monarchy interacts with government. As a man, you don't interact with government at all. So when these talk to the Lord's spiritual, temporal, and commons, they're dealing with those subjects not immediately in right of controlling the monarchy through their duty and power as fidei commissum. So when they're speaking about it, the people, they are not speaking to the people directly, they are speaking to the people indirectly who are changed into citizens by their accepted use of equitable interest to land. Now, remember to like and share, make comments for discussion, and any donation is also greatly appreciated. God bless in coming to know your true power. As for the mention of God bless, I will also clarify what I mean. I am not referring to all the man-made gods depicted in the world's religions and beliefs. The world is a fiction of law, after all, as we are all legal personalities that are currently used under this English law system. Remember, this tenable truth. I am God, but not the God you believe in, as you first must believe in yourself. Know that ye are gods, and ye will do greater work than I. Signed, man-made gods. Okay. Enjoy your research and have fun.